it looks like, according to all of the legal experts that I have been diligently analyzing and examining, that the Supreme Court is going to lean towards either delaying this January 6th insurrection case brought upon by Jack Smith, which many people think, I do too, that's a complete sham, just like every other trial. It's election interference. I mean, clear as day. And that this is going to be a huge win for Trump. I'm going to play you some videos. Wait till you hear the video I play you from Justice Clarence Thomas asking attorney for the people for the United States, I mean, if you could call him that, about, a really pointed question about Operation Mongoose and what about past presidents who have committed coups and operations, secret operations. Wait till you hear that video. But I'm going to play you some other videos too, some exchanges between Sotomayor and Ketanji Brown Jackson and Kavanaugh, several exchanges between the justices and the counselors who are arguing over the case. This is so important because Trump was in another court while this was going on. The fake Don, Judge Juan Merchan, the fake Don, told Trump that he had to be present in court or else he would be held in contempt and possibly face jail time. And so Trump couldn't even be at one of the most historic Supreme Court cases of all time in the history of the United States. He couldn't even be there to be a part of that argument that happened today. And so he was over at the hush money trial, the alleged hush money trial, just doing the best that he can to not, I mean, how this guy doesn't break just to me shows his steely resolve, his dedication and commitment to what he wants to do to bring this country back from the depths of the swamp that vegetable in chief Tombstone Biden has put us in. So check out this first video right here. And then after we check out these videos, I'm going to tell you why this is considered, based upon a heavy breadth of legal expert analysis, why this is considered a win for Trump. But let's check out this first video.
But it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
What Justice Sotomayor is basically arguing is that, and that's where that sort of creative language and legalese and semantics gets involved. How do you define one as personal gain and define one as quote unquote your responsibility? Because with all intents and purposes, you could argue that Obama murdering a bunch of innocent civilians with drones was not an official capacity, and that he could be tried for that. That's why this presidential immunity case is so historic. And I'm going to talk about that in a second, but let's check this out. And let me know in the comments what you think of what Justice Sotomayor and Trump's attorney was arguing back and forth about the different precedents. But check this out. This is absolutely amazing. Supreme Court Justice Clarence Thomas asks Michael Dreeben, attorney for special counsel Jack Smith, why previous presidents weren't prosecuted for various coups and operations such as Operation Mongoose. Listen to this.
In not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right, it would seem that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes.
I don't know if you guys heard that or not. And by the way, God, that guy's voice is one of the most difficult voices. That's exactly what he sounds like when I hear him. That's exactly what he sounds like. Let me know what you think in the comments. Oh my gosh, it's the weaseliest, nasaliest. It just seems like utter swine inside that rib cage of his. He says those are not crimes. So attacks on civilians are not a crime, Counselor Dreeben? So killing innocent civilians are not crimes? You see, the point of this argument is, the point of this back and forth is that you open up this can of worms and you essentially will be putting every single president, present, former, past, and future, under the scrutiny and jeopardy of being prosecuted criminally, which will de-incentivize and completely sterilize the office. And it could literally, I know this sounds far-fetched, but I truly believe this, it will stifle, it will prevent any future president from carrying out their duties to the utmost of the law and their own responsibility with what I like to call Theodore Roosevelt balls and courage and determination. It will weaken this office to the point where it is just a show and tell presidency. It's all just superficial. This is the most dangerous precedent. They're so salivating to go after Trump and stop him from running, stop him from being president again. It's so revealing how callous these people are, that they're willing to jeopardize literally the future of America. They're willing to jeopardize our strength, our courage, our resolve, our determination, our balls for the rest of all time. And with all intents and purposes, this literally could be the tipping point of the point of no return. Could be the point of no return. If this actually, if they get their way, if Dreeben, Jack Smith, and this elitist woke mind swine swamp gets their way, we've reached the point of no return. It's going to absolutely topple any kind of credibility, any kind of global perception, any kind of veneer, any kind of really what Kevin O'Leary said. It's going to kill the American brand. It's going to kill the American brand, point blank. Here's Ketanji Jackson Brown arguing that the president did not act in an official capacity. Check out this clip right here, and how Saar, Trump's attorney, essentially makes arguments that are quite contrary to Justice Ketanji Brown, quote unquote, DEI hired Jackson.
At least in the absolute immunity context, to tell us what are official acts and what are not. I mean, I'd understood that even in the, first of all, your ask is absolute immunity, isn't it?
That's our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official act, so then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right, so my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess, even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another?
So this is a really deranged argument from Ketanji Brown Jackson. She's basically arguing that President Trump was not acting in a quote-unquote official capacity on January 6th during his election integrity efforts. They're making it seem like the investigation of the 2020 election and the efforts to protect America's election integrity is not a quote-unquote official act. So the U.S. president has an obligation to secure America's elections from foreign and domestic adversaries. So this is where it's such, again, I'm just kind of trying to illustrate, these are dangerous precedents that this radicalized, weaponizing left woke mob virus consortium, that they're doing everything they can to stop this guy. They're doing everything they can to undermine democracy. It's so ironic that they say democracy is on the ballot, which it's not. For them, they don't give a rat's ass about us. It's so dangerous because you can argue, just like with any case, with any proceeding that requires legal processes and systems, you can argue officiality, you can argue personal, and that's such a scary tightrope that those lines can be blurred so easily and weaponize prosecution like we're seeing literally all throughout 2024 and even late 2023 with what's happening with our former president, Donald Trump, that they can persecute anybody they want to. They can persecute any official past, present, former president. Again, it's going to sterilize the office. If these guys get their way, it's going to sterilize the office for all time. If this presidential immunity is canceled, that Tombstone Biden could face charges for his open border policies. It could come back to kick you right in the butt, Blojo. Check this out.
Presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning.
Now, so what does all this mean? What does all this mean? So I want to defer to legal expert Mike Davis, who's chief counsel for nominations, Senate Judiciary, law clerk, as well as he's part of the committee and law clerk for Justice Gorsuch. So this is what he says. He says, after listening to arguments at the Supreme Court, it's clear the justices will narrowly hold the president of the United States, any president, is immune from the criminal prosecution for official, not personal acts. The Article 3 Project's legal analysts said in an official statement. Additionally, or alternatively, the court will reaffirm criminal statutes do not apply to the president unless they are explicit. The court will remand Jack Smith's January 6th case to D.C. Obama judge Tanya Chutkan for an evidentiary hearing. Her decision is immediately appealable to the D.C. Circuit, and the Supreme Court could take the case again before trial, all the while pointing towards this is going to be delayed. The court's likely holding will also substantially affect Fannie Willis's January 6th case. It's our girl Cash Money G. She always makes a cameo, doesn't she? And may affect Jack Smith's presidential records case. And the Supreme Court's Fisher decision on obstruction will likely destroy two of Jack Smith's 4 January 6 charges against Trump. Only 20% of Jack Smith's January 6 case will remain. The case will not get tried before the election. Bottom line, this will become a historic win for President Trump and the presidency and our country. This is a big step forward. This is a big step toward undoing the Democrats' Republic-ending lawfare and election interference against President Trump. Other legal analysts also agree, that no clear, concise majority opinion emerged this morning, but there may be 5 justices willing to kick the can down the road, and that's enough for Trump, at least for now. I couldn't agree more with Mike Davis. I couldn't agree more with other legal experts and analysts. I couldn't agree more with Trump's attorney, John Sauer, on the implications and the ramifications of what this does to the executive office, what this does to the office of presidency, and how it can sour, dilute, and sterilize this office moving forward. And I think once you sterilize the commander-in-chief, once you prevent them from, I like what he said, quote, fearless, boldless action that's needed and necessary. If they fear that, if they're trepidatious about that, I mean, being president of the United States, you're leader of the free world, you have to make decisions that could impact millions, if not billions of people. If you're afraid that you're going to get prosecuted, if that's always in the back of your mind, how can you make any fearless or bold decision? We're going to live in a society that is so woke, even the woke won't recognize how woke it gets. It will be so PC, it will be so Orwellian, so dystopian, so anti-American that we will not recognize this country. And that just gives more strength to our adversaries like China, Russia, and God knows who else. So I throw this off to you, Nez Nation. What do you guys think? I think this is a huge win for Trump. I agree with Mike Davis, but I would love to hear from you. So I throw this off to you. Let me know in the comments what you think down below. If you made it this far, don't forget, become a Nez Nation Insider. It's free. It's absolutely free. It's our free newsletter. It's in the pinned comment, show notes, and description. All you got to do is just click on that link right there. Click on free newsletter. Give us your best email, and bada boom, you are in. Check out these videos coming up here on the screen right now. And as always, God bless you, and may God bless America. I'll see you soon.